Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Reading the Tea Leaves. What are the top 10 risks your home health agency and/or hospice will face in 2025? Today's presenters are Robert Saltaformaggio and Matthew Catoe. Robert is a senior counselor at Lyles Parker. He focuses on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Robert represents clients nationwide. He has experience in assessing clients' records for documentation compliance in private payer and CMS audit preparation, as well as identifying and improving documentation deficiencies. As Matt is a new associate with the firm, prior to his time with us, he worked with the HHS OIG, both their investigation teams and with their Office of Counsel. Since he's coming back from the dark side, he brought the experience in anti-kickback, Stark Law, and False Claim Act compliance matters. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. There's another quick reminder, I will be sending out the PowerPoint slides via email tomorrow. So without further ado, I present your speakers, Robert Saltaformaggio and Matt Catoe.
Thanks, Gio. Why don't you go ahead and go to the next slide. Well, good morning or good afternoon, everyone. Matt and I would just like to say thank you for coming aboard. And before we kick this off, just a general reminder that although Matt and I are attorneys, this presentation is being provided for information only. It does not constitute any legal advice to you. If you have any particular legal concerns, please reach out to a healthcare attorney who can help you directly. With that said, let's go ahead and kick this off. We'd just like to start off with a quote from Supreme Court Justice Neil Gorsuch, who has a new book out, and the quote is, "Criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone can be arrested for something." And, as we know, we always hear that adage that, the average person commits like 100 federal crimes a day. And it just goes to show that, the regulatory state, especially within the healthcare industry, is just becoming a monster. And it seems like everything you could possibly do, it could be wrong, and that you might be subject to some kind of audit or legal concern. And so that's why we're here today to kind of outline what we think are going to be some of the 10 biggest issues that you should be aware of coming up in the next year. Next slide. So like I said, here's kind of a quick overview of the current enforcement environment. And as this picture kind of demonstrates, there are just a number of entities, both at the federal and state level, that can subject you to all sorts of legal hassles, whether they're ZPICs, UPICs, RACs, SMRFs, FUCUs, MACs, CERT auditors, you name it, there's an acronym for it. And so later in the presentation today, we'll kind of go over a few of these contractors, but again, you're facing a whole gamut of both the federal and state level. So we're here today to help kind of prepare you and, so that you're going to be able to, combat these folks if and when you do get audited or receive some kind of notice from one of these entities. Next slide. So just a brief overview of the enforcement. Not shown on this slide, kind of just a quick refresher, kind of going back to the early 2000s. Under the Bush administration, the enforcement oversight there was really broad. Enron was one big entity with whom we're all very familiar with, and it was crazy at that time that only one person ever went to jail for the Enron issue. And at the time, there just wasn't much enforcement going after individuals in particular. A lot of the federal enforcement kind of focused on the companies themselves. But then when President Obama came aboard, his administration really started to focus on not only, looking at liability at the company level, but also really starting to focus on individuals high up within the companies, whether it's the CFO, COO, whomever, who was largely engaged in any criminal misconduct, and holding those folks liable as well. And that kind of emphasis focusing on the individuals in addition to the companies have really carried over into the current Biden administration. So a couple of years ago, the Deputy Attorney General, Lisa Monaco, kind of refreshed that guidance, and that, in this paragraph, she says the department's first priority in corporate criminal matters is to hold accountable the individuals who commit and profit from corporate crime. So again, we're not just going to hold the companies liable, but we're also going to hold those important stakeholders at the company liable if they're also involved in any nefarious conduct. I think what's going to be interesting is what the second Trump administration will do. During, I guess you could say, Trump 1, they kind of pulled back a little bit and kind of reverted back to what we saw during the Bush administration, to focus more on the companies themselves and less with targeting individuals. But things can change. I mean, there's kind of a big populist streak in both parties where, we're going to not only go after the big companies, but we might go after individuals high up in those companies as well, if we find that they're liable and engaging in misconduct as well. So again, as that last line says, you can't expect to avoid personal liability by hiding behind, the organization settlement with the DOJ or HHS OIG. The government will come after you as well. Next slide. So then we'll go ahead and dive into, again, the 10 big risk issues that we see for 2025. And the first risk area for home health and hospice companies is going to involve these Medicare Advantage and Medicaid managed care organizations. And what we've seen over the last couple of years is that CMS is really trying to push a lot of the Medicare work to private payers and moving them into the Medicare Advantage and Medicaid managed care programs. Whether or not just the Medicare program under CMS has just gotten so big that it's just become even more difficult for CMS to handle, or if we've seen a lot a better focus in implementing care at the private payer level. That's going to be something we'll see, but we're really seeing CMS start to push a lot of the plans and benefits and care to Medicare and Medicaid patients to be managed by private payers. So one might ask, well, if private payers are sometimes more organized and can deliver better care than the government, well, what could be the problem? Well, next slide, Gio. The problem is that you have kind of limited appeal rights when the care is under these third-party Medicare Advantage or Medicaid managed care companies. If you have a beneficiary who is Medicare or Medicaid, a lot of the appeal rights are outlined in either the federal or state regulations. So just to use Medicare, for example, if you have a claim that's denied during an audit, you'll have several layers of appeal rights that are afforded to you that are outlined in the federal regulations, whether you go up through a redetermination, a reconsideration, to an administrative law judge, all the way up to a federal court. And the government can't take those rights away from you because they're outlined in the federal regulations. Well, all these other private payers, even though they're working on behalf of the government and taking these claims, they're not government entities. And so, they're going to be sometimes what we call these care delivery organizations, or CDOs. And the issue with working claims under these CDOs is that your contractual rights are going to be outlined in the private and the provider contracts or the payer contracts. So, we've seen that the appeals process is severely limited when dealing with these CDOs where, you might only have one level of appeal, and after that, you'll have to, either go to court or to some kind of arbitration with these companies. And, I had one client who dealt with remote physiological monitoring in Texas, and he found out that even though all of his patients were Medicare patients, they were all under this CDO program with WellMed. And, upon further review, looking at his contract with WellMed, that, after WellMed had denied all the claims on the first level of appeal, which it called reconsideration, there was no more appeal rights outlined in the contract other than going to arbitration. And, so what's going to happen is that you just see that there's a lot more restrictions when patients are moved over to plans that are managed by these CDOs. Next slide. Gio, next slide, please. So what should you do? Again, read those contracts. The provider contracts with these CDOs and these Medicare Advantage organizations are going to outline all your rights and appeal rights that are afforded to you, both with regarding to how many levels of appeal as well as the deadlines, where you only have 30 days to appeal or 60 days. And what's unfortunate is that every payer is going to be different. So your rights under a contract with WellMed is going to be different than your rights with United, which is then going to be different than your rights with Aetna. So it's really pushed on, a big legal minefield for hospice and home health providers who have patients that, while you traditionally may think that they're, in Medicare or Medicaid, might have had their plans transitioned over to a CDO or a Medicare Advantage program. Next slide. Okay, Matt, why don't you take over on risk issue number 2?
Sure. So I'm going to step in and for risk issue 2, our firm has identified non-compete clauses in employee contracts and independent contractor agreements. So these are for all of the current non-competes that exist and those going forward. As you may or may not be aware, the non-compete space right now under the Biden administration is tied up 8 ways to Sunday with federal and state injunctions based on a movement by the Biden administration to, for all intents and purposes, call non-competes illegal. That matter is currently under litigation and is making its way through the various circuits. It currently has at least 2 federal injunctions against it and at least 1 state. What that means legally is that there's a giant pause button on it. But if and when it gets resolved, we identify it as a major area of risk for hospice providers, specifically because of what the rules may or may not become, both under the current administration and the incoming second Trump administration. On April 23rd of 2024, the FTC's final rule issued a non-compete overhaul. It's a comprehensive ban on new non-competes with all workers, including upper senior executives. And for those existing, there is a carve-out for senior executives that does not apply to lower levels. Existing non-competes can remain in force on senior executive levels. Existing non-competes with all other staff are non-enforceable after the effective date. The 2 dates below are each of the injunctions. Specifically, the July 23rd was the FTC winning the case challenging the agency's rule. August 20th is the injunction stating there's a massive pause button, for want of a better term. The Trump administration in its incoming state is expected to, at the very minimum, review this matter and either affirm the complete ban on non-competes or reverse it simply because it was an act of the prior administration. As we can't predict the future, we are advising everyone to keep an eye on what the new rules are. Next slide, please, Gio. So for hospice and home health agencies specifically, we recommend that everyone do a review of employment contracts and especially the independent contractor agreements. Are they effective for what you want them to do? Can they be modified? Should they be modified or overhauled to protect either the business or the employees in that business? And the question of whether or not the individual covered under that contract, do they qualify as an independent contractor? Should they, and why, should really be spelled out in your contract terms as a matter of preemptive risk diversion. If you can hand a lawyer, in the event you need one, or any other investigative agency, the document that says this is what everybody agreed to, it's a lot easier to deal with than having to go find emails or phone calls or records. Or I thought everyone was on the same page, that we understood X and really everyone else was operating under Z. It's easier if you can just make sure those contracts are airtight from the word go. This can include non-solicitation agreements, non-recruitment agreements, non-compete language, any venues for disputes. If you want to get ahead of the curve and say this will be settled in X state or arbitration, can be included in those contracts, and we recommend a review going into the incoming administration. Next slide, please, Gio. The third risk issue are HIPAA matters. These are privacy issues that we all know, love, and secretly hate having to deal with. The compliance date of the privacy rule in October 2003 has kind of started as the benchmark for when everyone really started measuring HIPAA, leading to, as you can see on the screen, just under 500,000 HIPAA compliant complaints since 2003. As of August 31st of this year, the OCR has estimated $143,728,972 in fees, penalties, and fines in relation to these HIPAA complaints. So not only is the OCR very much looking into this, they're keeping an eye on it, they're making sure that everyone is compliant with the HIPAA guidelines, and if for any reason they determine you're not, they're not afraid to fine you. They do also make referrals to DOJ for criminal investigations in the event they're necessary. So while the OCR and the Office of Civil Rights may come after you civilly for your pocketbook, they are allowed to bring the DOJ along as well for an entirely related but separate criminal investigation. And you will require representation in both arenas, usually simultaneously, so it can get out of hand fast. The most common examples that we see of HIPAA compliance are impermissible uses and disclosures. This can be boiled down to someone who is not supposed to have access to this record or this information got access to it or has been provided access to it and they shouldn't have been, followed almost immediately by a lack of safeguards, i.e. you have to keep it protected from threats that you are aware of and those that you may not be aware of. A very common question OCR asks when their investigators first appear is to see the records in their current state. If they determine under their investigation that there are not enough safeguards, they can and will fine you for it. The lack of patient access is an interesting one. We've seen numerous issues where patients have asked for their health records, and due to delays or outright refusals, the patients don't get their medical records. And it's important to focus on the last half of that sentence. These are the patient's medical records. They are entitled to them by law. You have to give them over if the patient can otherwise verify that they are who they say they are. You can't withhold them. You can't obfuscate them. You have to give the patient their medical records. The short version is just don't open the can of worms. Give the patient their medical records and call it done with. Within reason, to that last bullet point, don't disclose more than you have to. Next slide, Gio. So this plays on what I was just going over, the right to access the patient records. In November of this year, the OCR announced a civil monetary penalty of $100,000 against a provider. And we would like to reiterate, that's against the provider, not against the organization, out of someone's personal checking account, $100,000. This was the result of an investigation based on the complaint that the provider had failed to provide a patient with timely access to their medical records. So if the patient has proven that they are who they say they are and they want their medical records, you should endeavor to get them to that patient sooner rather than later. We fully expect to see more of these cases going into the new Trump administration and into the year 2025. And this plays into our risk assessment of the lack of safeguards. There was an investigation in a Washington State hospital following the receipt of a breach notification report that 23 security guards in the hospital's ER used their login credentials to access patient records in the EMR system with no job-related purpose. This included multiple instances of PHI, and the hospital agreed to pay nearly $250,000 and implement a plan to update its policies and procedures, costing them more money in administrative costs on the back end to safeguard their protected health information and train their workforce to prevent the type of snooping in the future. The short version of both of these examples is there's two areas of risk under HIPAA, usually who gets access to the medical records, when and why, followed by are you as a provider or an organization doing what you're supposed to keep the matter private. Gio, next slide, please. And I'm going to go ahead and pass back to Salt for the False Claims Act liability.
Thanks, Matt. False Claims Act liability is going to be a big watch for both home health and hospice agencies going into the new year. And we just have a brief slide here, just noting that the enforcement efforts have really been accelerating post-COVID, and that we've seen, an increase in the monetary judgments and settlements involving fraud and False Claim Act claims against the government to exceed $2.68 billion in FY 2023, and out of that, $1.8 billion were attributable to healthcare-related cases. And kind of what we've also seen a real big uptake in is that the number of whistleblower cases rose to 712 last year. And what's a lot of these whistleblower cases, kind of, the genesis of them all involve kickback issues, which Matt will touch base on a little bit later. We've also seen a rise in new False Claims Act cases, which in the first time ever, more than 1,000 and then over 1,200 were filed in a single year. And that we've also seen last year that DOJ and whistleblowers were party to over 500 settlements and judgments, also a new record for a single year. Next slide. So we've also really seen an expansion of revocation actions against providers in the past year, and we really see that these will continue to expand going into 2025. On the slide in front of you are 22 of, ways in which the government can use as a basis to revoke your billing privileges. Often we see some of the biggest ones concerning home health and hospice. Number 5, the on-site review. The issue here is that a lot of times these government contractors will come perform their on-site review at the most inappropriate time for providers. And that time usually is in the middle of the day when you might have, your office might be out on lunch or have some other event, and the contractor coming by to perform the on-site review will notice that no one is around, and then will just claim that, hey, the business is not here at this address, and so it's going to be a basis to say that you lied on your application forms or on your reapplication forms, and that use it as a basis to revoke your billing privileges. I would say the number 1 issue we see is number 8, the abuse of billing privileges. Oftentimes we see this issue arise from high error rates after a number of audits. Whether it's you get a high error rate on your first audit. Generally, these Medicare or Medicaid contractors will perform a second or even third audit within a prescribed time period. And if you continue to demonstrate high error rates and not show to the government contractors that you're, correcting and rectifying all the issues and errors they find in their audits, they're going to allege that, you're abusing your billing privileges and will, revoke those privileges. A new one that we've seen recently that I'm personally working on is number 19, an affiliation that poses an undue risk. in this situation, I kind of just want to highlight it because it was fairly new to me. We have one client who was previously affiliated, and by affiliated, this individual was a senior manager and kind of administrator for a hospice who had their billing privileges revoked for number 8, an abuse of billing privileges after not doing great during several audits. And then our client, who was the owner of entirely separate hospice and home health agencies, had the billing privileges revoked for those entities simply because of her prior affiliation with the former company that had its billing privileges revoked. So even if you may own or affiliated with multiple home health or hospice agencies, and let's say there's 10 of them and 9 out of 10 of them pass every audit with no errors, and you've just been doing great for a number of years and have had no issues. If you're affiliated with that one bad egg, CMS is permitting contractors to revoke your billing privileges based on the issues with that one bad apple, and because you're affiliated with it. So that's something to be on the lookout with going forward. Next slide. These are just some additional proposed revocation authorities. Kind of want to just point out misdemeanor convictions. So no longer will just a criminal conviction make you be a mandatory revocation, but CMS is thinking about granting privileges for misdemeanors, which is any violation that results in a penalty of a year or less in jail, as a basis to revoke a provider's billing privileges. And then finally, number 5, debt referred to the U.S. Treasury. So if you've exhausted all of your appeal rights and you still have Medicare debt that is debt that is owed to Medicare, if that debt is then referred to the Department of Treasury, who would then feed it out to a third party to try and collect it, CMS can use that as a basis to revoke your billing privileges. So again, with the last slide, just know that there are a number of different measures in which the government can use as a basis to revoke your billing privileges. Again, the one I've seen the most is that abuse of billing privileges, where providers just consistently have a high error rate over multiple audits. So it's really important that you have an effective compliance program in place so that if and when these audits do come, you're going to be prepared to get that documentation in a timely manner and be able to complete those audits with a low error rate going forward. Next slide. For risk area issue number 6, we just kind of wanted to put up some vignettes just discussing criminal cases involving home health hospice agencies. Matt and I can sit here and talk about all the ways the law is wrong, but sometimes it's really good to get a visual picture of folks who have not been fortunate to sit through these presentations and who have come under the engaged in nefarious activities. So, in our first case in Houston, we had a husband and wife. The husband was sentenced to 12 months in prison, and the wife was sentenced to 4 years in prison because they were found guilty in a conspiracy to commit healthcare fraud. The wife was alleged to have obtained patient referrals by paying kickbacks to marketers, patients, and bribing physicians to authorize medically unnecessary home health services. Also, the husband admitted that he filed fraudulent cost reports to Medicare and attempted to disguise the kickback payments to his wife as legitimate business expenses. Down in McAllen, at the southern part of the state, we had someone sentenced that involved over $150 million in false and fraudulent claims to Medicare for home health and hospice services. According to the government, the company told patients that they were terminally ill when that was not even remotely true. And what's even sad, they apparently paid a chaplain to go visit the patients to make it look like, to tell the patients that they were terminally ill. The company made payments to their medical director fees contingent upon, certifying patients for hospice when they were not meeting the terminally ill guidelines. The defendant also received luxury trips, bottle service at exclusive nightclubs, and other perks for illegal kickbacks in exchange for certifying patients for hospice when they did not meet the eligibility requirements. Next slide. Again, back up in Houston, we have another owner of a home health agency sentenced to 57 months in prison for this conspiracy to commit healthcare fraud. The defendant was found to have billed Medicare for home health services that were not medically necessary. He also paid medical clinics for fraudulent home health certifications and unlawfully paying for patient referrals. Finally, again, down in McAllen, another home health agency owner was sentenced to 45 months in prison for this conspiracy to commit healthcare fraud crime. In this case, the owner had submitted false fraudulent claims to Medicare for reimbursement of services that weren't provided. Physicians had not authorized any medically necessary services and paying illegal kickbacks in exchange for information. So kind of what these four examples really show is a lot of the underlying issues with these crimes are the same. One, illegal kickbacks. Two, certifying for services that are not medically reasonable or necessary with respect to home health patients or for hospice patients, certifying that they are terminally ill when they don't meet the LCD guidelines, or submitting false claims to Medicare or to Medicaid. Those are going to be kind of the top issues that we see, both at the criminal level and then even going forward, which we'll talk about in a minute with a lot of the civil issues with the Medicare and Medicaid contractors. Next slide. So let's talk about these administrative audits of hospice claims. There's going to be 5 or 6 of these we're going to talk about. The first one is this special focus program, and that was designed to monitor hospices identified as poor performers based on certain quality indicators. Hospices that are under the tutelage of this SFP audit program are given additional oversight that is really there to help them improve their administrative and patient admission practices. Unfortunately, any of the hospice agencies that fail to resolve any issues or deficiencies identified in the SFP have seen their privileges either revoked or that they've been terminated from participating in the Medicare program. Another program is this PPEO, or the Provisional Period of Enhanced Oversight. So what CMS found a couple of years ago was that it was seeing a significant rise in the number of hospice agencies that were starting up across several states, one of which was Texas, but also included Arizona, California, and Nevada. And so in this program, the hospice organizations undergo several rounds of review. The PPEO program will perform a records request and then perform several rounds of review. After each round of review, the providers will get some education to try and help improve them in any deficiencies that are identified. And what we've seen in this PPEO program, some of the biggest issues they've found is, again, documentation submitted does not support the terminal illness. The physician narratives are either not there or are not valid. In my experience, some of the issues I've seen with physician narratives is that they're not a narrative. So, you can't just write on the physician narrative just a list of the patient's, terminal diagnosis and then list out any other comorbidities and secondary illnesses that are affecting the patient. You really need to, in a narrative form, outline why the patient's conditions meet the guidelines under the LCD to qualify for a terminal diagnosis. The hospice election statements are either not meeting the regulatory or statutory requirements or not in the patient records. We're also seeing, those certifications or the certifications are not timely signed. And then finally, we've also seen reductions in the hospice continuing care hours. Next slide. And well, really quick, we'll stay on the slide, but one thing, another client of mine with this PPEO program who went through 2 rounds of audits with the reviews with the PPO program, and unfortunately failed to make a significant improvement in their error rate, and CMS used it as a basis to allege that there was an abuse of billing privileges and had that provider's privileges revoked. So we can see that the PPO program, although it's there to help hospice organizations improve their documentation and admission guidelines, if you're not reducing your error rates and really following through with the education provided, it can really lead to some heartaches, including revocation. So similar to the PPEO program is the Hospice Targeted Probe and Educate, or TPE audits. It's very similar in the fact that you'll undergo around 1 TPE, and if you don't get an error rate sufficient to the government, you'll be subjected not only to education, but additional rounds of TPE. And if you go through up to a 3rd round of TPE and fail to, reduce that error rate, you can be subject to, administrative consequences, including suspension and, unfortunately, revocation. Similar to the PPEO program, a lot of the denial reasons are very similar. Again, eligibility for hospice is not properly documented, or the patients aren't meeting the guidelines outlined in the LCD for hospice. There's missing face-to-face documentation. As you all know, for a hospice, after for your 3rd benefit period and later, you have to have a face-to-face encounter that then the facts outlined in that face-to-face document is used by the certifying physician as part of the process to certify, I should say to recertify for another benefit period in hospice. Or here, again, a 3rd missing or incomplete certifications or recertifications. The biggest issue there I see with the research of the certifications is, the lack of a good physician narrative, or the certifications and recertifications not being timely signed. Next slide. Another administrative audit program is what's called the CERT audits, for the comprehensive error rate testing. These CERT audits are primarily focused on reviewing the MAC, the Medicare Administrative Contractors protocols, to make sure that they are properly paying claims, or if the claims don't meet the coverage guidelines, denying claims. Unfortunately, that doesn't mean providers are going to be off the hook, because if the CERT does identify that the MAC, incorrectly paid for claims that didn't meet the coverage guidelines, you're still going to be found to have an identified overpayment, and you're going to be generally liable for it. But I would say, out of all of these different programs, the CERTs are probably the most benign. But again, we're still going to see a lot of the same issues with the CERT auditors. Again, inadequate or missing physician certifications or recertifications, issues with the beneficiary election forms, untimely signed physician certifications, inadequate or missing face-to-face documentations. So, I know I'm repeating myself, but we really see the same, like 4 or 5 issues across all of these auditors, and a lot of the times, it's not the gray area that sometimes terminal prognosis can be, but it's easily correctable technical issues. Next slide. Okay, another auditor of the SMRCs, or the Supplemental Medical Review Contractor. Noridian has been performing these SMRC audits. A lot of times we see that the level of hospice cares have been a primary issue in denying payment within these SMRC audits. And we're still seeing, though, again, as the primary denial reasons, it's going to be the same that we just talked about. We really saw kind of a decline in the number of SMRCs in 2024, but we think that next year we're going to see a resumption of them going forward. And like a lot of these audits, if a provider fails to do well in a SMRC audit, or through any subsequent appeals that you may pursue, that Medicare can use this as a basis to perform some kind of administrative action, whether it's suspending or revoking the agency's Medicare billing privileges. Next slide. Finally, UPICs, or the Uniform Program Integrity Contractors. I mean, we see these not only for hospices, but for home health agencies as well. The UPICs, their primary focus is to detect, deter, and prevent waste, fraud, and abuse. So most of the administrative audits we encounter with both home health and hospice providers all deal with these UPIC audits. For hospices, you know, again, it's going to be the same denial reasons that we've spoken about previously. I would say with respect to home health agencies, a lot of the denial reasons we see with UPICs are, you know, the plans of care are inadequate or are not timely signed, issues with the face-to-face encounters. As you know, for our home health folks, the issue with the face-to-face has to relate to the primary reason that the patient is going to see home health. So if the patient sees a doctor, you know, for a basic cold or some other issue, you can't use that face-to-face as the basis for the patient for some other condition if that's going to be the primary reason. The reason for the face-to-face encounter has to relate to the primary reason the patient is undergoing home health care. We've also seen issues with medical necessity of the services themselves, whether it's skilled nursing, PT, OT, ST, or home health aid services were not medically necessary. Those are kind of the big significant issues we see with home health audits and these UPICs. Next slide. Okay, now I'm going to turn it back over to Matt, who's going to finish out with our remaining risk issues.
Did you think we were done? Haha, no. In addition to all of the other audits, these are the federal regulations that all medical healthcare professionals in the United States are expected to abide by. The major risk area we expect to see starting us off is the anti-kickback statute. The legal citation is there for you on screen, and it is under the anti-kickback statute. It is a crime to knowingly and willfully solicit, receive, offer, or pay any remuneration in return for referrals, purchasing, leasing, ordering, or arranging for any goods, facilities, or services that may be paid in whole or in part by any federal, state, or healthcare program. Translated from its legal jargon, there are three big takeaway pieces here. The first is that red underlined phrase, knowingly and willfully. That is a scienter element in the law. That means there has to be intent. Now, that's helpful if you, in the event that you find yourself on the wrong end of an anti-kickback statute investigation, but it's not as defensible as one might see, because intent can be derived from circumstance, meaning you may not have known directly that it was an anti-kickback, or whatever document at issue may not say this is a kickback in bold underline. But if there can be if there's enough circumstantial evidence to put together, the government can and will infer that there was knowing and willful intent behind the actions at issue, and they will hold it against, guess who? You. The best way to think about this is there can be no remuneration, anything of value, not just money. It can be ski trips, it can be dinners out, it can be, well, the wife and I are going out on a yacht to Cancun. Would you like to join us? By the way, I have a friend. No, full stop. Do not do it. Because the second line, in whole or in part, for any federal, state, or healthcare program, if you have 5 patients and only one of them is federal, and that patient is deemed to be inadequate or incorrect in its upload or usage of medical personnel or billing statements or services, the whole batch can be dragged under an anti-kickback statute. Additionally, under President Obama's Affordable Care Act, a person need not have actual knowledge of this section or specific intent to commit a violation. This is underlining what I just went over. It says knowingly or willfully, and what the follow-up under 6402 of the Affordable Care Act says is you don't have to speak legalese for us to tag you with this, is the short version of what this says. This change is noteworthy because, again, it lessens the requirement for the government to bring a criminal case under the anti-kickback statute. Next slide, please, Gio. So these penalties under the kickback statute can get very serious very quickly. There are sentences of up to 10 years in prison, up to $100,000 worth of fines, exclusion from both the federal and state associated healthcare benefit programs, a fact that Salt was referring to earlier. That can also cause problems for your business in that if there's an exclusion issue, and civil monetary penalty fines of up to $50,000 per violation. That means not just one item and not just one patient. If your patient comes in for a general checkup, you determine they need some blood work while they're here, we might as well knock that out. And by the way, let me re-up your cough suppressant. Each of those individual line items can be its own violation under the anti-kickback statute. And there is something known as treble damages, which is what that last line is in reference to. They can say, we take all of these $50,000 instances, every single one of them. We put them all in a pot, and we put a ×3 on the end of it because we think your behavior was that egregious. That is allowed under an anti-kickback statute investigation, and it is done frequently. Now, I do see it relatively as a scare tactic. Most of the time, the government is not going to throw the entire book at a provider or an organization, but it is there, and they can pursue it if they choose to do so over the course of the litigation. This penalty is live until the investigation is concluded. At any point until there is a final verdict, they can put the treble damages multiplier in there. So we warn our providers in hospice and home health, if you see any letter come in that even looks like it's anti-kickback related, we encourage you strongly to get a healthcare attorney on the phone now, immediately, to get in front of it. Most courts have adopted an expansive reading of the knowing and willful intent, going back to what I was referring to earlier. And the Third Circuit adopted the one purpose test. So again, if the payments were intended to induce the physician to use cardiomet services, the statute was violated even if the payments were also intended to compensate for professional services. In the case on the screen, these matters were otherwise legitimate or had otherwise legitimate purposes. They just had a few bad eggs in the batch. The government held in the Greber case that that was not enough to escape anti-kickback statute litigation, and they can and will hold it against you if there's even one bad apple. Do not take the anti-kickback statute lightly. It can get out of hand quickly. Next slide, please, Gia. There are safe harbors for the anti-kickback violations. As the anti-kickback statute reflects, the scope of potential coverage is extraordinarily broad. Therefore, Congress has made, over the course of the life of the anti-kickback statute, 47 individual safe harbors. They are voluntary, not mandatory. And the translation for most of them is, under any other circumstances, this would violate the AKS, except you complied with our checklist, so we'll let it go. That's a very loose interpretation of what the safe harbors are, but it applies for purposes of our presentation today. I do want to point out that not only are the safe harbors voluntary, but they are, one, subject to change. They can be added to or removed at congressional discretion, and they are very specific. If you are attempting to comply with any or all of the safe harbors in any billing arrangement whatsoever, you must check every box under that particular safe harbor without exception, exclusion, no ifs, ands, or buts about it. If you miss one, the safe harbor is null and it does not apply. Next slide, please, Gio. The most likely safe harbors in the home health and hospice areas specifically are in referral to personal services and management contracts, as well as employment safe harbors. Each of these safe harbors are quite complex, going back to what I was saying earlier, and typically require legal assessment to determine whether a proposed business arrangement qualifies under a specific safe harbor. If you believe that you are attempting to comply with a safe harbor, we again strongly recommend contacting a healthcare regulatory attorney to double and triple check your work, because God forbid someone misses anything like a comma somewhere that throws one of the checklists out the window. The safe harbor becomes moot. Another example is physician ownership of home health or hospice agencies may, and I say again, may be protected under the small entity investment safe harbor, but compliance is extremely complex and meeting every element of that safe harbor is generally impossible. Consult your healthcare counsel to double check you if you intend to make use of the safe harbor. We cannot stress it enough. Hire a lawyer who specializes in healthcare regulatory compliance like SALT, myself, or our peers to double check the work. Next slide, please, Gio. These are the changes to the personal services and management contracts based on payment regulations. Under this final rule, remuneration does not include payments made by a principal to an agent as compensation for the services, so long as every single one of those boxes is its own individual element that has to be checked 100% to completion for this safe harbor to apply. In the interest of time, I won't read the entire change to the risk issue, but this is an example of the change to the personal service and management contracts regulation. This is looking at the safe harbor. Each of those 6 boxes on screen in their entirety have to be gone through for all instances in which the questionable physician, business, contract, relationship, whatever it is that is in the crosshairs of the anti-kickback statute, every single line item, every single penalty, everything has to fall under those checklists, and it must be correct in order to escape the anti-kickback statute under this safe harbor. The methodology generally has to be set in advance, consistent with fair market value, and an arm's length transition. And most importantly is that third circle bullet right there on the screen, about 3/4 of the way down. It is not determined in a manner that takes into account the value or volume of any referrals or is otherwise generated between the parties for which payment is made by Medicare, Medicaid, or federal healthcare programs. Translated from legalese, whoever the company, hospice, home health agency is doing business with cannot receive more remuneration based on how many referrals they turn over. That is the biggest and most crimson red flag that there is, and the most likely to draw DOJ, OCR, or any other piece of the alphabet soup's attention. If anybody is getting more money based on how much business they're bringing in, you are running a risk of getting looked at for anti-kickback statute violations. Next slide, please, Gio. This is the employment safe harbor. In a similar realm to its previous one with the employment contracts, the bona fide employee safe harbor to the anti-kickback statute violation states there's no violation by an employer to an employee with a bona fide employee relationship with that employer for the employment and the provision of covered items or services. You may recall earlier in this presentation, we brought up independent contractor and employee contract issues as a risk area. This is why. If you want to comply with an employment safe harbor, the employee has to have a bona fide relationship, which is defined elsewhere in the statutes. And as you can see in that last line, the anti-kickback statute employment safe harbor is an affirmative defense on which the defendants have the burden of proof, meaning you, if you are in the crosshairs as the questioned hospice or home health agency, will have to prove the bona fide employee relationship. And that's where we referred to earlier in the presentation, check your contracts. If you think you've checked them thoroughly, do yourself a favor, get ahead of the risk, be ahead of the curve, just check them again, make sure everybody's in compliance. The Fifth Circuit has found that the safe harbor provision adopts the definition of the employee as set forth in Chapter 26 of the United States Code, specifically that subsection on screen. They further noted the general common law of agency rather than the law of any particular state. This means that the federal rules control as opposed to any particular state exception when looking at the anti-kickback statute violation generally. And the list of factors they consider are listed on screen for your convenience. In the interest of everybody's time, I'm not going to read them off individually, but please feel free to review them when Gio provides the slides later. Next slide, please. There are recent kickback. Here are some areas that we've seen kickback risk areas uptick, more interest from the federal entities, entering into business relationships with an individual or entity that has the ability to refer business to your home health or hospice agency. Any old school dine and dash approaches might be out the window, but giving lunch or other goodies, especially liquor. We cannot stress enough, liquor is one of the hot ticket items, followed very closely by gift cards, sporting event tickets, or any referral source. It does not have to be money. Remuneration in the statute is best defined as anything of value. It does not have to be a check. It doesn't have to be cold hard cash. If it has a monetary value that the government can point to and say, in exchange for the referrals, you were getting X, that can be a cognizable issue under the AKS, and they can and will take you to task over it. Next slide, please, Gio. Now, medical director agreements. This is a risk area adjacent to the anti-kickback statute, specifically because of the very unique role that medical directors hold while they work with home health and hospice agencies. The OIG, when consulted about fair market value in June of 2015, stated a clear warning to everybody who employed a medical director. Compensation paid to physicians under medical directorship arrangements constitutes improper remuneration under the anti-kickback statute, for a number of reasons, including the payments took into account the physician's volume or value of referrals, and that does not fairly reflect fair market value for the services performed. Again, translated from legalese, there cannot be any pay scale whatsoever in the healthcare world, regardless of home health, hospice, hospital, anything and everything in between. If you get more money for more referrals, you're probably in violation of anti-kickback statute regulations, and you should really reevaluate that relationship if you want to continue to do business with that entity or if you want to overhaul everybody's contracts. OIG also alleged that some of the 12 physicians cited in the June 2015 opinion had entered into the arrangements under which an affiliated healthcare entity paid the salaries of the physician's front office staff. Because these arrangements relieved the physicians of a financial burden that they would have otherwise incurred, the OIG alleged the salaries paid under these arrangements are improper remuneration for the physicians. These are medical director agreements as it pertains to a risk issue. This is the 2015 guidance, and it keeps in mind medical directors have a unique role while dealing with home health and hospice, but they should nevertheless be monitored and making sure that how they're getting paid is in line with fair market value. Next slide, please, Gio. Risk issue 10 is the failure to exclude individuals and entities. The OIG, HHS, and several other federal entities regularly publish a list of excluded individuals. These exclusions are a final administrative action that is a bar, usually a complete bar with limited exceptions, in all federal healthcare programs. Examples include, but are not limited to, Medicare, Medicaid, TRICARE, any federal healthcare payor program. If you are excluded from one, you're usually excluded from all of them. Secretary of Health and Human Services has delegated the exclusion authority to my former coworkers, the Office of the Inspector General. If they show up, they have the exclusion penalty, and you should be aware of it. They may not necessarily make an issue out of it, but they can. It is an option. Patient safety and financial integrity of federal programs are the primary concerns whenever exclusion enters the table. Mandatory exclusions and permissive exclusions are two different types. Mandatory is exactly what the name says. As the law is written, there is no ifs, ands, or buts. There is no appeal. If you check one of the boxes under the mandatory exclusion list, you must be excluded. The most common are imposed as a result of convictions for program fraud, patient abuse, and certain drug offenses. Permissive exclusions are discretionary and can be imposed for a broad range of conduct, and Salt was mentioning earlier, consistent failure of audits in the TPE realm can be one of them. If enough people are irritated at the OIG and they say you've consistently failed and you repeatedly failed to take our audit seriously, they can use the exclusionary penalty should they so choose. Most of these actions involve nurses and nursing assistants. Physicians are involved in about 9% of permissive exclusions, and business owners are usually involved in 3%. It is also worth mentioning, this is a federal analysis that we're providing here. Each state has their own parallel exclusion authority and considerations for Medicaid and other state programs. Be aware of what they are and make sure you're not violating them. Next slide, please, Gio. The OIG's primary concern about the participation of excluded individuals are patient safety and risk fraud. Just under half of all exclusions are related to licensing issues, and the main reasons are license revocation due to substance abuse, fraud, professional misconduct, and patient abuse. Approximately 50% of all exclusions are based on felonies related to the healthcare program itself, or specifically to patient abuse, neglect, fraud, or illegal substances. All excluded employees, regardless of where they are, whether they're at the front desk doing the paperwork on patient intake or they are the head physician in the office, if they have a previous exclusion, it presents a serious risk to any and every organization, and it is the organization's job to do their due diligence when hiring and employing these individuals to double check and make sure that these individuals have not shown up on any of the exclusion lists. Next slide, please, Gio. Failure to exclude, here are some recent enforcement actions. There are multiple states on screen. We do want to draw attention to California because the pediatric home health company paid $377,000 to resolve the allegations that an office manager who was previously excluded was employed. I want to point out again, that's an office manager, not a doctor, physician, or nurse. The office manager, and the company also agreed to be excluded from participation for 20 years. So for the next 20 years, that company cannot do business with any of the federal healthcare, Medicare, Medicaid reimbursement programs. You need to be aware of the excluded lists and who's on them and whether any of those individuals are trying to gain employment with your facility. Multiple other examples are on screen. In the interest of everyone's time, I'm not going to read them all. Please feel free to review at your discretion when Gio publishes the slides later. Gio, next slide, please. And that should about wrap it up. We are open for questions at this time, right, Salt?
Yep. Gio, do we have any questions today?
Yeah, I think we have one. So it says risk issue number 6. Let me see. It says inadequate benefits this elections. Can you please elaborate on this one?
Say that again. What was the question?
So it says risk issue number 6. Inadequate benefits election. Can you please elaborate on this one?
Let me go back and.
Inadequate benefit election. Is that one of the examples?
Yeah. Well, I don't know the specific details of the cases if that's involving risk issue 6, but I do know, issues with inadequate benefit elections, either from what I've seen in audits is that either the election statements have not been included in the records, or the election statements are not signed, dated, or elsewhere, they don't meet other regulatory guidelines. The patient doesn't identify who he or she would like to be as their attending physician, or doesn't check off, appropriate, saying, I don't care who it is. So again, there, as you all know, with hospice election statements, there are certain requirements that must be included in those statements, and either if they don't meet those requirements or are not timely signed and dated, that's where we've seen denials with regard to that specific issue.
And just to piggyback off of that, I am currently working a case where that is an issue. The paperwork specifically related to the signatures and the appropriate elections and narratives behind them don't back up what was submitted to the payor. So we are working a case where the paperwork in the elections benefits process, like Sal just mentioned, is an issue. Do we have any other questions, Gio?
No, that is only one question for today. So I'm going to just end it. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Robert Saltaformaggio and Matthew Catoe. Everyone from today's webinar will receive copies of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Lyles Parker. Have a good Wednesday and take care. Thank you, guys.
Thank you all.